The Supreme Court of the United States just sent a warning to every anti-gun state in America. And I am not talking about a subtle legal signal buried in a footnote. I am talking about the justices themselves, out loud, on the record, during oral arguments, telling states like Hawaii, California, New York, New Jersey, and Maryland that their gun laws are in serious constitutional trouble. Most gun owners have absolutely no idea this happened. The mainstream media barely covered it. But the legal community is watching this very closely, because the warning the Supreme Court just sent could unravel gun restrictions across the entire country before this summer is over. Every word in this video comes directly from SCOTUS blog, NPR, the Constitution Center, the NRA-ILA, Duke Center for Firearms Law, Bloomberg Law, and official Supreme Court oral argument transcripts. Let's get into it. To understand the warning, you have to understand what these states did and why the Supreme Court is so angry about it. In Bruen, the court, 6-3, struck down a New York law that required a permit to have a gun in public and necessitated that a person show a safety need for that permit. Justice Clarence Thomas wrote the opinion for the court, stressing that the test used by many lower courts was not sufficient to protect gun rights. The Bruen ruling was a massive victory for gun owners. But rather than comply with it, several states did something extraordinary. After the Bruen decision was issued, these same states defied the Supreme Court by passing laws that supposedly conformed to the opinion, but that made licensure just as difficult, expensive, and impractical as before. The laws used various subterfuges to accomplish this, the most audacious of which was the vampire rule, which presumptively bans licensed carry where it is most needed, the private companies and properties where people go about their business in public. A federal judge in California saw exactly what was happening. U.S. District Judge Cormac Carney granted a preliminary injunction blocking California's law, which he wrote was sweeping, repugnant to the Second Amendment, and openly defiant of the Supreme Court. Openly defiant of the Supreme Court. Those are not the words of a gun rights advocate. Those are the words of a federal judge appointed to uphold the Constitution. And the Supreme Court itself has now taken direct aim at these defiant states. On January 20th, 2026, the Supreme Court heard oral arguments in Wolford versus Lopez, a direct challenge to Hawaii's vampire rule. And what happened in that courtroom sent a shockwave through the legal world. The Supreme Court heard oral argument in Wolford versus Lopez, a case about whether states can ban people from carrying concealed firearms on private property without getting the owner's consent. Under the Hawaii law at issue, any armed person who wants to enter a shopping center, restaurant, or other privately owned property that is open to the public needs express authorization first. For example, a sign at a store's entrance or a verbal okay from an employee. The questioning from the conservative justices was withering. Various justices repeatedly asked if Hawaii was in effect treating the Second Amendment as a second-class right. If a political activist has a right to wear on his blazer a campaign button at a restaurant without affirmative consent from the restaurant owner, why are the rules for guns different? Why, several justices asked, should the Second Amendment be treated worse than the First Amendment? Chief Justice John Roberts pressed Hawaii's attorney directly. Chief Justice John Roberts questioned Neil Katyal, who was representing the state of Hawaii, on how rules about property owner consent presented First and Second Amendment conflicts. You said part of the history and tradition is there's no right to enter private property without the owner's consent, right? Roberts asked Katyal, who agreed. Roberts then pointed out that people assume the right to enter a gas station on the highway without express permission. And Justice Neil Gorsuch delivered perhaps the most pointed moment of the entire hearing. Justice Neil Gorsuch was deeply disturbed that Hawaii defended its statute in part by pointing to an 1865 Louisiana law that prohibited people from entering private property with guns without the consent of the owner, a statute that lawmakers originally adopted in order to disarm black people. Gorsuch marveled that people who would normally react to such historical anti-black laws like garlic in front of a vampire are now citing those very laws to promote gun restrictions. After oral arguments, legal analysts at the Duke Center for Firearms Law concluded that it seems likely the conservative justices will strike down Hawaii's law and constitutionalize the current default rule, making the status quo the baseline that determines which state actions are constitutionally suspect. Now here is what most gun owners are missing. Hawaii is not alone. This ruling will send shockwaves through 5 states simultaneously. Hawaii's vampire rule is a historical and contemporary outlier. Every other state with a similar rule, including California, Maryland, New Jersey, and New York, saw it invalidated by a federal appellate court applying Bruen's historical standard. Think about what that means. California, Maryland, New Jersey, New York, 4 of the most anti-gun states in America, all passed the same type of law Hawaii passed. And every one of those laws has already been struck down at the appellate level, except Hawaii's, which survived the Ninth Circuit and made it to the Supreme Court. In New Jersey, after Governor Phil Murphy signed what gun rights advocates called a carry killer bill in a complete rejection of the Supreme Court's holding in Bruen, the NRA challenged the law. A 3-judge panel of the Third Circuit Court of Appeals upheld most of the law, but the court granted a petition for rehearing en banc on December 11, 2025. Oral argument was scheduled for February 11, 2026. In Maryland, the Fourth Circuit Court of Appeals heard oral argument in a challenge to Maryland's own Bruen response law. The Fourth Circuit ultimately determined that Maryland's rule would effectively declare most public places gun-free zones, but that likely stretches the sensitive places doctrine too far. And on the same day the Supreme Court heard Wolford arguments, the Fourth Circuit handed down its own ruling. The Fourth Circuit held that Maryland's prohibition on carrying guns on private property held open to the public is unconstitutional. That ruling, on the same day as the Supreme Court oral arguments, sent an unmistakable message. The courts are moving against these anti-gun state laws simultaneously from multiple directions. The warning from the Supreme Court did not stop with Wolford. On March 2, 2026, the justices heard arguments in a second gun case, United States versus Hemani, and once again the questions from the bench revealed deep skepticism toward the government's position. Justice Neil Gorsuch questioned the government's position by pointing out that John Adams took a tankard of hard cider with his breakfast every day. James Madison reportedly drank a pint of whiskey every day, and Thomas Jefferson claimed he only had 3 or 4 glasses of wine a night. Gorsuch asked whether all of them were habitual drunkards who could properly be disarmed for life under the government's theory. Justice Amy Coney Barrett confessed to being stuck because she said there is no evidence that the defendant's use of marijuana every other day was dangerous, or that he should be convicted of a crime and deprived of his legally purchased and properly stored gun. Justice Samuel Alito noted that the most commonly used drugs today, heroin, methamphetamines, fentanyl, had not been invented at the time of the founding. Marijuana was not consumed to any significant degree until the early 1900s. Alito concluded, "We don't know what those who adopted the Second Amendment thought about illegal drug use per se." These are not the questions of justices who are preparing to rule against gun owners. These are the questions of justices who are searching for a constitutional basis to limit the government's power to strip gun rights from Americans. Here is the complete picture as of April 2026. The Supreme Court has already heard oral arguments in both Wolford and Hemani. A decision in Wolford v. Lopez is expected by late June 2026. The questioning in both cases strongly suggested the conservative majority is prepared to rule against anti-gun state laws and against the government's expansive interpretation of who can be stripped of gun rights. There is a real chance that appeals courts will not make significant moves in gun cases until the second half of 2026, after the Supreme Court has rendered decisions in Wolford and Hemani. Legal experts note there will be a lot of momentum to just wait and see, and once those decisions drop, the floodgates could open. The current era of Second Amendment jurisprudence is still relatively new. Under the Bruen framework, courts must first ask whether the plain text of the Second Amendment is implicated by challenged conduct. If so, the government must show that the law aligns with this country's historical tradition of firearm regulation. That burden is proving very difficult for anti-gun states to meet. The Supreme Court has sent its warning. California, New York, New Jersey, Maryland, and Hawaii have all heard it, even if most gun owners have not. By late June 2026, the legal landscape for carrying a firearm in this country could look completely different than it does today. Subscribe to this channel. Share this video with every gun owner you know. The warning has been issued. Now it is time to pay attention.